Today's speaker requires very little introduction as I'm tearing apart my computer here. Um, we're very fortunate today to be joined by Neil Kalin, Assistant General Counsel of the California Association of Realtors. He's been working for CAR for over 30 years, Senior Legal Advisor to CAR's Standard Forms Committee, author of amicus briefs for CAR for the state and federal courts, and was recently the co-chair of the 2019 Real Property Law section of the California Lawyers Association. Wow, that is very impressive, Neil. So welcome and thank you for being here today.
Pleasure to be here. Thank you for inviting me. We got just a filled hour and I'm going to try to get right to it. Give me a second while I share my screen. Legal update, June 10th, 2021. Wonderful, good. Orange County Association of Realtors. Glad to be here. Glad to be back. I've spoken with you before and it's always a pleasure to do so. So what are we going to cover today? Well, we're going to cover some new laws, or actually new law, the new and revised forms. I'm selectively picking them. Reopening and real estate, what it means for brokerage practice, such as open houses and showings, and maybe kind of sort of what it means for brokerage offices and companies. So we'll talk about that. And a couple of hot topics that seem to be going on everywhere and in your area too. And we will have time for Q&A. So let me jump right into it. So the only new law that's really coming up now, because of course, when do most new laws start? Most new laws start in January, but we have this one new law that's starting July 1st, and it concerns defensible space. And it's found in California Civil Code 1102.19. You may have heard of 1102. That's where the transfer disclosure statement is found and all of the related laws. This is really part of that whole grouping, right? What does this new law apply to? Applies to sale of residential 1 to 4 properties. Naturally, it's in that TDS section, right? But only ones that are located in a high or very high fire hazard severity zone. Okay, so residential 1 to 4 properties, if they are located in a high or very high fire zone, and only if a TDS is required. As you know, there's a lot of exceptions to giving the TDS. If the property, the transaction is TDS exempt, then guess what? The defensible space law does not apply to that transaction. Look at my next bullet point. What has been out for a while since the beginning of the year is the form dealing with home hardening. Home hardening disclosure has already been out. What CAR did is we updated the home hardening form. It is now the fire hardening and defensible space form. Essentially, what's the difference between home hardening and defensible space? Well, home hardening concerns the structure itself and whether the structure, the improvement itself, is vulnerable to fire and catching fire. Defensible space is really different. It's concerning spread of a wildfire and making sure that there's a buffer zone between the structure, plants, trees, combustible material, dead grass, stuff like that around the property. And if the defensible space is kept up according to code, hopefully that will either slow or minimize the spread of wildfires. So two different things that are going on there. Just in case somebody wants to see it, this is a nice little chart or graph from CAL FIRE. It shows that you've got a 100-foot zone, you got a 30-foot zone. You actually also have a little 10-foot zone. Kind of hard to see it, but right there in the little house, it's showing a chimney, and you cannot really have tree branches closer than 10 feet to a chimney. So normally we talk about those two zones, 30 and 100 feet. There's also a third one. There's this 10-foot zone for trees that are too close to a property. But it's a nice little graphic for those who want to, show their clients. So what does the defensible space law require? Well, it requires compliance or documentation of compliance with either the state or the local law. And you're going to hear a little bit about that in just a moment. There may be different requirements depending on whether there is a local ordinance in effect, right? And one of the important things to look out for the local ordinance is, does the local ordinance allow for compliance after the close of escrow? Or does the local ordinance require compliance before close of escrow, in which case it would really be a point of sale requirement? All right, so here's just the heading of the new form, the new revised form: fire hardening in a defensible space. Notice it says advisory, disclosure, and addendum, right? So it's all three. The advisory portion of it, well, that's just information. That's all. You know, good information that somebody might want to read if they're interested in the subject. The disclosure, well, remember I said this law is found in the 1102 series. The disclosure portion of it makes it what? Well, creates a statutory cancellation right, what you're familiar with the transfer disclosure statement. So if you're in a transaction and the TDS comes after the contract has been signed, then there's going to be a 3, or which it's usually going to be a 5-day cancellation right, depending on how the TDS is delivered. This form carries with it that same cancellation right. What are we finding in some parts of the state? People are trying to avoid that cancellation right. The only way to avoid it, pretty simple. The TDS has to be delivered prior to the buyer making the offer on the property, and the buyer needs to acknowledge receiving it prior to making an offer on the property. But the really new part here, the part that's most important, is this addendum portion, because although it's put into this disclosure statute, the law basically says buyer and seller have to agree. So it's kind of the statute saying we're going to have an agreement to agree on how we're going to address compliance with the defensible space law. Because of that, this form really needs to be signed by both parties. So the seller will typically initiate it, needs to get it back signed by the buyer. Now, just like with the TDS, that in the real estate purchase agreement, the buyer is obligated to return back a signed copy of the TDS, so you know you're going to get it. But even if you don't get it, as long as you can prove that the TDS has been delivered, the cancellation right will end after that 3 or 5 day period. Because this law requires an addendum, it does need to get back. It does need to be signed by the buyer. So you typically, the seller is going to initiate it. You need to get it back by the buyer. That's the addendum portion of this form. So let's take a quick look at it. Here's most of page 1 of the form. You can see the first part is really just advisory. It's talking about the fire hardening laws, the defensible space laws, and if you have an inspection report. That's it, information only. Paragraph 1B, where do you locate this information? The best place is through your natural hazard disclosure company provider. And maybe you can look at the report and figure it out. Maybe you need to contact your rep or whoever your contact is at the NHD reporting company. Notice paragraph 2. We just default, we say, you know, the home is in one of these higher, very high fire zones. That may not be the case, right? It may not be the case where your property is located. I was just giving a speech 2 days ago. They're not anywhere near a zone, right? But what I'm hearing throughout the state is that there's a lot of brokerage companies that are saying, we're just going to put this on our checklist of forms that need to be provided, right? So if that's the case, the forms being provided, the default is 2A. Why did we do the default that it's in a zone? Because we'd rather over disclose when you're not in a zone than under disclose if you are in a zone and you don't know it, right? So that's why we chose that as a default. But if you find out, because you know your area where you're selling property, that the home is not a zone, you can get that information from your NHD reporting company, the seller can see it. Well, guess what? It's the seller who fills out this form. The seller can check 2B then and say, the home is not a zone, right? Maybe we'll provide the rest of this information. Maybe we'll fill it out. Maybe we won't. It won't matter. Because if it's not in a zone, you don't have to use it at all. But if your brokerage company is making this form a requirement and you know the seller knows the home is not in the high or very high fire zone, great, then check the box in 2B. That's simple. Paragraph 3 is what you would have seen already for the last 6 months, which are, yeah, well, more than the last 6 months, actually, that deals with home hardening and whether there's vulnerabilities. Notice in this block there on the left, there's different requirements for when these different rules apply, right? So for fire hardening, same thing, 1 to 4, if a TDS is required, higher, very high fire zone, But the fire hardening, only applicable for pre-2010 properties. When we get to the defensible space, we drop the requirement for pre-2010 properties. It's applicable to any property that's in that zone for which those conditions apply. And the third requirement for an inspection report, only 1 to 4, and if a TDS is required. So slightly different times when these 3 different elements of the law come into effect. All right, so let's look at the rest of the form. The big part that for the new law, by the way, the new law comes into effect July 1st, and it's for transactions that close on or after July 1st. That's why we introduced this form last month, right? To take into account that there's an escrow period. You could have entered into a transaction last month that does not close until on or after July 1st. Okay, that's why we did not wait until the June form release to release this update. So we look at paragraph 4B, top of the screen. It talks about the defensible space requirements. There's basically, the way we looked at it, there's really only 4 things that could happen. If there's no local ordinance for where the property is located, then either the buyer's going to have to comply or the seller's going to have to comply, right? So if compliance can happen after close of escrow, B1, that's our default. Buyer, you're going to comply within 1 year. If the seller has already obtained compliance within the last 6 months, then guess what, seller? You're going to provide that compliance document to the buyer. Pretty simple. What if there is a local area that has their own defensible space requirement? Well, it's going to be the same thing. If compliance can be done after close of escrow, then you're going to be looking at B3. The buyer will comply after close of escrow. If compliance has to be done before close of escrow, guess what? That's going to be a seller responsibility. We really don't see any overlap between B1, B2, B3, and B4. It's going to be one of those 4 situations. How are you going to find out? Well, guess what? Your association has been working with the fire agencies in your whole general area. And I guess, and it sounds like what a good association you have. Hopefully you're going to be having a webinar coming up soon, giving you information for how you find this out, how you can get inspections, whether there's going to be a cost for inspections. So you are very fortunate that you belong to the Orange County Association of Realtors or one of those neighboring associations. So lucky you, you'll be able to figure this stuff out. A lot of areas, it's very difficult to figure out. Notice our default position here in paragraph B is that there is no local ordinance and that the buyer is going to comply. We may find out as time goes on that more and more cities are adopting local ordinances, and we may wind up having to change the default, but we thought, at least at this point in time, that's the safest default that we can have. So again, remember, the form is going to need to be signed. Typically, it's the seller who's going to be initiating it. So you see that sort of little yellowish off yellow box. That's for the seller's signature. Look what it says right above the signature. It says, and agrees to the applicable terms in 4B, right? That's the agreement. This is going to become an addendum. And then you see right below that red box, the buyer's signature, and it says the same thing right above the buyer's signature, and agrees to the applicable terms. Both buyer and seller agree, boom, you have your addendum, okay? And if this doesn't apply to you, then you don't have to worry about it that much, and you think about checking that box in 2B. All right, there we go. That is our new law segment. Let me ask you, Lisa or Tiffany, who I see is still on, are there any questions dealing with fire hardening and defensible space?
Yes, we do have a couple that are in our Q&A box, and if anybody does have questions throughout this webinar, please enter them there and we will bring them up at the end of each section. We have a couple that probably just require yes or no answers. Would it be wise to give the FHDS on every sale for a listing agent?
I think that's probably the best action to take. So I'm not saying yes or no. I think it's the best action to take. Unless you are absolutely certain when you take a listing that you know it's not in a very high fire zone where it's not needed at all, you might as well be cautious and provide it. And then if you find out later on, then you could check that box in 2B, or your seller can check that box in 2B.
Okay, so that kind of goes with another question that was asked, and then I will throw one more in. So this is only if the home is in a fire zone, and if it is not in a fire zone, we do not need to provide it. Question from the audience.
That is correct,
Okay,
right? Remember the 4 conditions: residential 1 to 4 property that's in a high or very high fire zone, because home could be in a moderate zone. If it's in a moderate fire zone, the law does not apply, right? And a TDS is required in that transaction.
okay, there's one more quick one here then before we move on to the next topic. We had a question, and to understand the statement, the inspection report called out in the report is the NHD.
No. So here, the inspection report we're talking about is an inspection for whether the property has complied with defensible space.
Okay.
What I'm saying is you could look at your NHD report to figure out if you're in a high or a very high fire zone. Once you figure that out, then in order to determine compliance and whether there is an inspection report, you're looking at a defensible space report, not the NHD report. Okay.
Okay, perfect.
Right.
We do have a few more questions, but if we have time at the end of the presentation, we'll ask those then. So moving on.
Moving on. So we're talking about a couple of the new and revised forms. Let's start with the new one, a transfer of listing agreement. Why did we do this? Well, we think we needed clarity, we needed protection from liability, and we needed protection from licensing discipline because of what our standard forms committee members were hearing about what was going on in the field. So let's take a look at this. This is brand new form, transfer of listing agreement, coming out a little bit later this month. The date for the forms release this month is the week of the 21st. We always hope they're going to be released on the 21st on that Monday, but you never know. Sometimes things happen, so it may not be released on that Monday, but usually they're pretty good. Here's the problem our committee was trying to address. Salesperson brings in a listing to a company, call that company A. The salesperson is working on the listing. Maybe it's an escrow, maybe it's not, it does not matter. The salesperson leaves company A and starts working for company B. The salesperson continues to work on that listing. That creates a number of problems, right? So first off, under the real estate licensing law, a salesperson, an agent, can only work through one broker. Well, the listing belongs to the brokerage, not to the salesperson. So unless the listing has been transferred to broker B, the salesperson is working for broker B, but working on broker A's listing. That's a disciplinary, that's a licensing problem. Second problem, liability, okay? Hopefully nothing goes wrong with that transaction, but if something does, guess what? Who has potential liability? The original broker and the new broker, and of course, the salesperson who's doing something wrong anyway, right? E&O coverage. A lot of licensees have E&O coverage. Not everyone, but most of them, I think, do. Well, guess what? The E&O coverage may not apply when a salesperson was working on somebody else's listing, and may not apply on either side of that transaction if there was some kind of negligent act. And last, and probably just as important, is does the seller really understand what's going on? You know, when even though they've been familiar with a particular salesperson, but now there's a different brokerage involved. Our answer to that, let's provide some documentation to clarify the issue. That's what the transfer of listing agreement does. In that opening caption paragraph, you identify, is this a residential listing agreement? It might be a lease listing, who the principal is, what the property is, who the broker is, if the property is in escrow, and who the new broker will be. So you're identifying all your parties. Paragraph 1, very clear. This is a transfer. Guess what? The listing shall be assigned to and transferred to a new broker. Very clear, okay? I want to point out something that's not highlighted in paragraph 1. It's actually the last sentence there. It says, if new broker and principal sign a new agreement, that listing agreement shall replace the current listing agreement, right? Because this form is presuming we are doing an assignment. There does not necessarily need to be a new listing agreement between the principal. We say principal because it's normally going to be a seller, but if it's a lease listing, it's not going to be a seller, right? It's going to be a landlord or a property owner. So we say principal. If the new broker says, no, I want a new listing agreement, great. That's going to completely replace the old one. But if not, then the listing just transfers and is assigned from number 1 to number 2. Pretty simple. Another issue that our forms committee said, we need to address, is there going to be consideration? The listing belongs to that broker number 1. Maybe broker number 1 wants some compensation to allow it to be moved. So the question is, if that happens, who's going to pay? Is it going to be the principal, or is it going to be the new broker? In which case it would be operate kind of like a referral fee. Okay. And if it's the principal, what it's going to be for. So our committee thought the most common occurrence is for out-of-pocket expenses. That's 2A, but there may be no requirement that the principal pay anything, and that's 2B. If it's going to be the new broker, okay, it's going to be a percentage of the total gross compensation. But look what it says after that red box in 2B, earned by new broker based upon the principal's side of the transaction, right? So assuming this is a seller, only the seller side of the transaction. You transfer the listing, you're not going to get credit for the buyer side of the transaction as part of essentially your referral fee, okay? Maybe there's not going to be any compensation from the new broker to the old broker. Well, that's 2B2. Pretty simple, right? Now, since the listing belongs to the broker, why would the broker not want compensation for transferring the listing? There could be a variety of reasons. Maybe the broker realizes, it's working this way today. Maybe tomorrow somebody from another office will be coming to my office, right? So it all will kind of work out in the end. Or maybe the broker saying, I am so happy to get rid of this principal. I don't want any compensation. I just want to get rid of this principal. Matter of fact, you may even be happy to get rid of the salesperson that's leaving too, right? And just say, just get out of my life. I'm very happy with my brokerage, the way it's working. Move on and let's forget about it. Paragraph 3, pretty clear. We're saying that, not only is the agreement signed, but the agency relationship is terminated. Paragraph 4 addresses an important issue, which is if the property is already in escrow, what happened when the purchase agreement was signed? Well, that original listing agent, right? There was a confirmation of agency in the purchase agreement between listing broker number 1 and the principals, buyer and seller. Now we're having a new listing agent. Notice this, no option here. It says, if it is an escrow, new broker, you shall provide an agency confirmation form once you take over that transaction so that everybody is aware who the new broker is. Our committee was looking at this situation. They said, something we need to think about, which is MLS. Now, I don't know if you have more than one MLS in your area or not, but some MLSs say, you know what? When you transfer, you need to cancel. Some just allow the MLS listing to be transferred to the new broker. Since we don't know where this is going to happen, in what part of the state, and what rules the MLS is going to have, we need to allow for both options, and they're there in paragraph 5. Paragraph 6, you're not likely to use because this is most likely to occur with the sales transaction. Most sales brokers don't keep trust funds for sales activity. So that's going to be unusual where that paragraph is necessary. Paragraph 7, we wanted to address the agent who is in most situations going to be leaving the office. The agent is not a party to this transaction, but we wanted to identify who that salesperson was. And we wanted to identify when that salesperson is no longer affiliated with the original broker, right? I mean, there's a possibility you can use this form 7B if the agent remains affiliated with the broker. If for some reason the broker is just allowing the listing to transfer to another company while the salesperson stays, we think that's going to be a rarity, but we did throw that in there just in case it comes up. Paragraph 8 is kind of a direction. Hey, guess what, salesperson? You're not a part of this contract, but you have the obligation to transfer all of your files that have not already been sent to the original broker. We look at the signatures on this form. Who signs it? The principal, broker one, broker two, which is the new broker. There's a spot for the agent to sign, but not as a party to this transfer of listing. Instead, just acknowledging the responsibilities that come with it. Something I do want you to pay attention to, though, in the broker signatures, both broker and new broker. Remember, when a listing comes in, who signs the listing normally? It's the salesperson, right? Because the salesperson has typically actual authority to enter into a listing agreement on behalf of the brokerage. Well, if they have authority to enter into a listing agreement, do they also have authority to terminate or transfer the listing agreement? Probably not in most offices, right? So we said, if this transfer is going to occur for both the old broker and the new broker, the salesperson does not have the authority to sign. You need to have a signature from either the broker or an office manager. So something to keep in mind with this new form. All right, I'm going to talk about two of our revised forms right now. And the two that are the most widely used, the residential listing agreement and the statewide buyer and seller advisory.
Neil, before we hop into that, we do
Yeah.
have a couple of questions
Oh, okay.
specific to the form you just discussed.
Sure.
And the first one was, in lieu of this form, can't the first broker do an ABA with the agent's second broker?
Well, then they would then the old broker would still be involved, right? If that's the additional broker acknowledgement, okay, or agreement. Can't remember what the last word is. I think it's additional broker agreement, but that means there would be a co-brokerage arrangement. That is not what this form is designed for. This form is designed when the old broker says, we are through, and everything is going to be taken over by the new broker. So two different concepts there. You had another question, I thought?
It was in the questions. I see that it's not here now, but I'm going to ask it anyhow.
Okay.
If you are a broker associate, does this affect you differently?
No, because the way most broker associates work with their agreement with the broker is they are essentially acting in the capacity as a salesperson. So there really would be no difference.
Okay, and we do have one last one. After the transfer, does the agent have to go back to company A to renegotiate the commission with the principal, since it will impact the company? Company A's referral commission. I think I got that right.
So if the original company wants to get a referral, then the salesperson can be involved in that discussion. There's no problem with that. But remember, you're going to put that term right there into paragraph 2, right? So while the salesperson may be involved in that discussion, who has to agree to it? The broker or the office manager, right? So, I mean, realistically, they're not just going to totally disappear during the course of that discussion. It's obviously going to be relevant, but the salesperson does not have the final say.
Fantastic.
Okay.
Moving on.
Moving on. So let's start with the listing agreement. There's a couple of paragraphs that have been changed here. Probably the one that deserves the most attention is right here, paragraph 10C, broker and seller's duties. So the first thing, I don't even have it highlighted, it's C1. It's referring to a form that has been attached to the listing agreement since September of last year, the Fair Housing and Discrimination Advisory Form, right? Good form, very topical with what's been going on, especially the last two years, in this state and in this country, really. And what does that form do? It tells people about fair housing issues. It identifies protected classes in California. It talks about buyer letters. Some people call them supplemental letters. Some people call them love letters. A lot of different names for them. It talks about what they are. Basically what? A way to influence the seller to accept the buyer's offer. And in today's competitive market, everybody's looking for an edge, okay? It defines, by the way, a buyer letter is not necessarily a letter. It could be a photo. We're seeing people who are sending videos. They're all under the general caption of buyer letters, okay? And what does that FHDA form say? It says, you know what, there's the potential for unlawful discrimination to arise as a result of these letters, right? They're not inherently illegal in any way. But because of information that comes in and because there are so many protected classes in California, there's a potential that the information might be used the wrong way. Even wrong information may not be taken into consideration, right? So they're not necessarily illegal, but they create a lot of problems, especially in today's environment. And that information is really discussed in that FHDA form. So our committee said, we're really concerned about these letters being used out in the field. So we're taking a listing. We're going to take a default position. Seller, you're instructing us, just don't present these letters. By the way, seller, we're not accusing you of being discriminatory or being unlawful in any way. We just don't want any problems. So we're trying to keep you out of trouble, right? So just give us the instruction. That's what this is. Paragraph 10C, 2A. Just don't present any of these letters, whether they're presented separately from an offer or they're presented with an offer. And guess what? If they're presented with an offer and you can't strip it out, then you're going to need to go back to the buyer's agent and say, my seller's instructed me not to present offer or buyer letters. I cannot strip this out. That means I can't present your offer. Write it up, send it to me again without the buyer letter, right? You have that authority with 10C2A. You may have a seller who wants to take these things into consideration. That's the seller's right. You cannot prevent a seller from doing that. But we say at CAR, if the seller wants to do that, you need to have the seller make an affirmative decision. Seller's gonna have to check that box in 10C2B. And notice the warning language there. Seller, if you do this, you are acting against broker's advice. Something that's not highlighted here is at the very last sentence, the very last part of 10C1, I want to make sure you pay attention to. Broker will not review the content of buyer letters. It doesn't matter if they're going to be presented or they're not going to be presented. You're not going to review those letters. Why? Because two reasons, really. One, we don't want you as a broker making a judgment call as to whether the letter is potentially discriminatory or not. That's a legal judgment. Stay out of that, right? Two, we don't want you to have that information where you might intentionally or be acting, on some kind of implicit or inherent bias that you just weren't even thinking about. We don't want you to be put in that uncomfortable position that the seller might be put in. So we're just saying flat out, you're not going to review the content of these letters. If you see one come in, if you have the instruction not to present, you're just not going to present it. You're going to send it back. Okay, moving on. What else has changed here in the listing agreement? Well, we look down to paragraph 10E, investigation and reports. These are reports that the seller is authorizing be obtained at the time of the listing. Look there, that first sentence, the default is seller is agreeing to order, and if necessary, to pay for it this time, an NHD report. Why did we think that's so important to do at the time of the listing? Well, because of this information that's going on with the defensible space and the FHDS form, right? How are you going to know whether the property is in the high or very high fire zone if you haven't gotten this report up front, right? So we're saying get it at the time of listing, find out from your NHD reporting company. The only way to do that, the seller by default is authorizing that be ordered at the time of the listing. There's a lot of other options there that maybe you in a practice think are good reports for a seller to get. Again, pest control, roof inspection, pool inspection, that's fine. Those are just optional. Check the box if they're applicable to you, your practice, or your broker's practice. There's another change made. It was actually earlier in the form, but to me, it's not as important. It's how to deal with coming soon status and days on market. And what CAR has found, as a matter of fact, the MLS committee even had some kind of a task force or working group to try to figure out what to do with this, and found there is just no statewide standard dealing with coming soon and days on market. So the best we could do at CAR in a form is to address the two issues this way. Notice the default right above the little yellow box. It says seller does, and only if you check, does not authorize broker to utilize coming soon status. So that gives broker the greatest degree of flexibility. But we don't know how that's going to affect days on market. And of course, in today's market, where prices are very dependent, a lot of homes are selling very fast. But if somebody sees that a home has been on the market, I mean, now it could be a week, but maybe it could be a month, all of a sudden it's looking stale, right? And so maybe that might impact the marketability of the property. But because different MLSs have different ways of calculating, all we could say in a statewide form is, you need to have this discussion with your seller client. Okay. All right, one more form I'm going to talk about, the statewide buyer and seller advisory, used in almost every transaction. Why is it used so much? Because there's not enough to read in the purchase agreement, right? Let's throw in another 67 paragraphs to have people go through. So what did we do? We did a few really good things, I think. When I say we, I mean the standard forms coding. First thing is we redesigned the table of contents page. What it used to be was you had those categories A through G, and in those categories, they listed every paragraph in those categories. But our members are telling us it's really kind of hard to find. We know every buyer is not going to read through all 67 paragraphs, but some buyers have certain concerns and they want to focus in on those paragraphs. I know it's hard to find them. All right, so I said, well, what's a way to make it easier? Let's put an alphabetical index of all the paragraphs. Now we have that. You could just look down alphabetically, find the paragraph that your client is expressing a particular concern about. It tells you what page to find it on, and you can direct your client directly to it. So we think that was a really good, effective change. What are the other things that we did? Well, one thing we did, add a paragraph on fire hardening defensible space. We already talked about that. I don't think I need to spend any more time on that. Here's a little chart also from Cal Fire. And then we added two new paragraphs, one dealing with wildlife and one dealing with sea level rise in coastal properties. The wildlife one was kind of interesting. We had a former chair who came to us and said, I had a friend who, lived out in the mountains, and they came home, and what did they find, waiting for them in their cabin, right? A bear. It's like, don't you think we should have a bear disclosure? And the rest of our committee said, well, that's kind of a little narrow to put on a statewide buyer and seller advisory, a bear disclosure. But bear's part of wildlife. Wildlife affects anybody, no matter where they live. Matter of fact, the next example I'm going to show you, I've actually visited one of my wife's friends in Beverly Hills, and we were driving down, we saw a whole family of this, and I'm not talking about possums or raccoons. What did we see? Coyotes, right? Actually, where I live in a pretty urban area. I live probably a couple of miles away from the hills, and I see in the Nextdoor website every week, there's somebody writing about a coyote sighting, okay? Whether it's on the street, whether it's in a park, whatever it is, right? So wildlife affects you no matter where you are. We said, let's address that issue. That's paragraph 6. And sea level rise, of course, has been getting a lot of attention, maybe even more now with the current federal administration we have. And so it's not just coming home and finding a bear or finding a coyote, it's coming home and finding that your, ocean view property is, ocean property, whether it's, when you look at that chart down there for the anticipated, whether it's 5 years from now, whether it's, 30 years from now, whatever it is, let's give people a bunch of resources that they could look at if those are concerns to your clients. Hey, just in case you want to know, we talked about the transfer listing, we talked about the fire hardening form, the residential listing, the statewide buyer and seller advisory. Here are all the other forms that are being released on June 21st. Lisa, anything else you want me to address before we move on to our last 2 subjects?
Yes, we had a couple of questions in here,
Okay.
and One of them that just came in was a question about, can we put the phrase "no buyer letters" in the MLS?
Yes.
I do that.
Okay.
And then we had another question, because I guess the fair housing thing kind of stuck on a couple of people here, which is
Okay.
good. We like that. Can we get something added to the lease listing agreement saying that the landlords and agents should not be asking for a copy of driver's licenses with an application to lease to avoid fair housing violations as well?
I could put that thought down. There are many different thoughts about how to deal with driver's licenses. And so I know the issue has come up in our standard forms committee, but I will write that down and forward that comment to them.
Okay,
Okay.
fantastic. And then we had a statement in here. An agent demanded that my agent submit a buyer letter. I told her no, and she should send executed FHDA and tell agent their request is illegal. Now, would our client have potential recourse against seller by insisting and potentially now discriminating against our buyer by not submitting a letter?
Okay, so let's go back. A letter is not necessarily illegal. A letter that makes reference, some, reference, inadvertent or not, to a protected class is not necessarily illegal, right? So one of the biggest problem areas, quite honestly, is with pictures. Somebody showing their family, you can see somebody's race, you can see somebody's ethnicity, by looking at a picture. But that's not necessarily illegal either. What's illegal is taking that factor into consideration in the decision to accept or not accept somebody's offer. Okay.
Yeah, I think that comment about the implicit bias is so important, because you can't unsee what you've seen.
That's absolutely true, which is why we said we don't want you reading really or even looking at the buyer letter. Once you've identified something, this is a buyer letter, brokers, we want you to stay out of it. Okay, that's the best practice. So is it illegal? No. One of the advantages of the new listing agreement is now you have instructions in writing from your seller saying don't present, right? Because under the real estate law, there's an obligation to present all offers unless instructed to the contrary by the seller. This is that instruction to the contrary. In the current situation where maybe you do not have that explicit instruction, then if I was a listing agent, I'd go to my seller and say, we think this is a problem. What do you want us to do about it? Okay. And then whatever the answer is, confirm your understanding in writing with the seller. If the seller says no, great. You can confirm that. Maybe if the seller puts it in writing, you put your confirmation letter to the seller. You can send that to the buyer side agent. If the seller says yes, you've got your protection. The seller said yes. Okay, couple of good questions. Thanks, Lisa.
Wonderful, thank you. And now moving on.
Moving on. Okay. So June 15th, there's going to be this big California reopening. What does it mean? Well, really quickly, we've got open houses and property showings, and kind of look at the list. Basically, nearly all the COVID protocols are going away for open houses and showings, right? No physical distance, cleaning. Cleaning used to mean cleaning before and after each showing. And then just recently was modified to say cleaning at least once a day. Hey, you're not even gonna have to do that, right? Starting June 15th. No PEDs, no sign-ins, no nothing, no prevention plan, all that stuff is going away. You don't have to worry about capacity limits as long as you're below 5,000 people. Not many homes are gonna take that many people, right? There's still gonna be a restriction about wearing masks. And here's the good general rule, right? Mask, you see it underlined on the right side of the screen. Masks must be worn indoors unless everyone is fully vaccinated. Well, if you're having an open house, how are you going to know if everyone is fully vaccinated? You're really not going to know. So basically for open houses, the rule should be everyone's going to wear a mask. If you're having a private showing, that's easy. You could ask everybody there if they've been fully vaccinated, then even they and you would not have to wear a mask. Okay. Can a seller have their own insistence that goes above and beyond what California law will require? The answer is yes, the seller can set their own rules, right? Seller may say, I want everyone to wear a mask. I don't care if they're vaccinated or not, okay? Seller could say, I want everyone to show me proof of vaccination or proof of a negative COVID test. Seller's allowed to say that. Should I get the seller's instruction in writing? Of course, because otherwise you don't know and you don't want to have a dispute with your own seller later on. Can a seller say, I want everyone coming into the property to sign something like the PED form or the recently released and soon to go away property sign-in sheet, where people make an affirmative representation? Yeah, seller can do that. Now, I just said our PED form's going away, our property sign-in's going away. So take a good look at it now, because if your seller wants to do that, you're gonna have to create one in your own, okay? And I put up some, resources there that I'm going to skip over for now. So let's say the seller wants to do something more restrictive. Well, what are you going to do? I say use the modification of listing, etc. form. People used to be called the modification of terms, form MT. Look at the beginning. Another reason I'm raising this is you may have taken a listing before. Maybe the property isn't sold. Maybe the property is back on the market, whatever it is. You also used the form that we had out called the RLA CAA. That was the code. It was the listing agreement coronavirus addendum. And that RLA CAA form said you're going to use PEDS, you're going to post rules of entries, you're going to have the broker practices form in place that everybody has to sign. That's not going to be relevant starting June 15th. So if you still have a listing and you use that form, you really want to get rid of it. That form says it will go away when the principals mutually agree, the seller and the listing agent, or when all of the orders disappear. Well, guess what? Something that I just found out yesterday, which is even on June 15th, the California governor's emergency order is not being revoked. Right? California is keeping the emergency order in place. They're just lightening up on the rules. So all the orders are not going to go away. So how can you change that form? Very simple. Use this MT form. Go into the, identify the listing agreement. Pretty simple. The RLA CAA dated blank is terminated. There you go. Then you don't have to worry about, we're not really complying with our own contract anymore. What if the seller wants restrictions? Add something like this. The following showing requirements shall be followed, and list out what the seller wants to have done. Okay, there you go. There you have it. These forms all being discontinued on June 15th, all 10 of them. Okay. I was going to talk a little bit about broker offices. There were these, let's see, interim temporary rules. I can't even remember what the name was from Cal OSHA, that we're going to have different rules depending on whether people were vaccinated or not vaccinated. Do you have to wear masks, not wear masks? Do you have social distancing, not social distancing? Well, we just found out yesterday, last night, that what we thought were going to be adopted, which were these temporary rules, were rejected by Cal OSHA. Now they're going to go back and they might come up with some kind of new rule, and I believe the date is June 17th. I know your association is on top of this, and I'm sure you'll be informed as to what the rules are, but I don't want to spend a lot of time on something that is so in flux right now. Okay, so that's it for the new rules to June 15th. Quick question, and then I'll try and burn through really fast my last topic.
Okay, we have one question regarding this. Isn't asking for negative COVID test or vaccination proof opening up for a lawsuit for a HIPAA violation?
Fortunately, I was just involved in a webinar yesterday with CAR, and our true expert on things dealing with office, Jenny Lee, was there. And she said, no, because HIPAA only applies to a very narrow subset of entities. A seller is not one of them. A brokerage is not one of them. So no, it's not a HIPAA violation, right? But that being said, The issue is, what do you do with that information? So how are you going to do it? You can either ask for the person who's coming into the home to self-certify, in which case you're just going to be operating on the honor system, no problem. If you ask for some kind of proof, there's a couple ways to deal with it. You could say, oh, okay, so you've shown me your vaccination card, or you've shown me your negative COVID test, in the last, whatever, 48, 72 hours, whatever the current guideline is. Thank you very much. Put it back in your pocket. Enjoy looking at this home. Another option is you get the information and you keep it. Keeping it is problematic. It's problematic for a brokerage. It's problematic for a seller. There's all sorts of privacy issues that come into place. Indeed, if you're a brokerage as a kind of an employer, you actually have to keep that information separate from all of your other records. So that's a real record keeping problem. If the seller is insisting upon that, and I'm a brokerage, I think I need to have a serious talk with my seller, because now I have exposure, not COVID exposure, but I have privacy exposure for keeping this information. It's not a HIPAA violation, but it's really putting the company at risk if the seller wants you to keep the information or deliver the information to the seller. So that's the best way I can answer that question.
Okay, and we have one other one. Can you quickly go back to the forms that will not be needed anymore? I'm actually going to miss the PED at this point.
There you go, really quickly. So the PED, the PRE, which is the rules of entry, the BPPP is the best practices, the RLACAA is the one that I said you want to modify and get rid of. The CVA is one that would modify a purchase agreement. It was probably used a lot in March and April last year, and I think it just kind of died after that. NUCC is the notice of unforeseen circumstances. There was a CVA for lease rentals and NUCC for lease rentals. The brand new property sign-in sheet, which we're not going to need. I mean, you may want to have your own sign-in sheet, but it doesn't have to have any representations on it. And the, I don't know, the listing agreement, open house addendum, I don't even remember what the LOHA stands for, but it's a form that's only been around for like 2 weeks and it's going away. So that's that. Let's really, I know I'm running up against a deadline here. I think we had an 11:30 deadline. I think we might go over a little bit if that's okay with Lisa and Tiffany.
I was just going to ask Tiffany if that was okay. She says it's fine. So,
Okay.
We got a lot of good stuff to cover. So you go ahead and then we'll get on to some of our questions if we still have time.
Okay, great. So what are the two hot topics? First one, non-contingent offers. The other one, switching of financing. So let's deal with non-contingent offers first. A truly non-contingent offer means there's no contingencies at all. Okay, so I want to remind everybody, there are two contingencies in the body of the purchase agreement that can be removed in the purchase agreement. And that's the loan contingency and the appraisal contingency. I'm going to show you those in a minute. All the other contingencies, the investigation contingency, the title contingency, for example, need to be removed by a separate form, the contingency removal form. Okay, but let's say you have a completely non-contingent offer. Here's some things that I think need to be thought about, whether you're representing a buyer or representing a seller. So, representing a buyer needs to know, no contingencies, buyer. If you back out, you do not have a contractual excuse to get out of the contract. You can be liable for damages, which, if a liquidated damage clause has been initialed, you're generally talking about your deposit, right? If the liquidated damage clause is initialed, there is a cap on that, generally 3% of the purchase price. But beware, you're not going to have a legal excuse. It's going to be really hard for you to say you're not in breach of contract. I think sellers need to be aware that even though there may be no contractual right to cancel, there could be the statutory right to cancel. Remember, we talked about the 3 or 5 day rescission right with the TDS and now the FHDS. That cancellation right applies even with a non-contingent offer. How do you get rid of that? Like I say, in some parts of the state, they're giving that information up front before the offer is made. I need to tell you though, even though we hear a lot about that, really started in the San Francisco Bay Area, that's really a minority of the state. Most of the state does business the way they've always done business. You get an offer and then you make the disclosures. So you need to be aware of that. If that's the practice that you're following, you need to be aware of what the consequence is. Okay. What about release of the deposit? If there is a breach, does the release happen automatically? I think sellers need to know, no, the release does not happen automatically. If there's a dispute, it cannot be amicably resolved. Then the parties go to mediation. After mediation, they would either litigate or arbitrate. Okay, that's how disputes get resolved under the purchase agreement. If you have a small amount in dispute, $10,000, parties can go straight to small claims court. I'm guessing you're not seeing a lot of those types of disputes. Okay. The other thing I just want to mention, and I have it actually in both spots, which is, I think at some point you have got to tell your principal, whether it's the buyer or the seller, you've got to say, what's more important to you, being right or selling or really buying a property, right? Maybe in order to buy a property, you're going to get out of one, you're going to be in breach, you really want to move on, okay? Is it more important for you to be right, or is it more important for you to get into another transaction? And if you're fighting with the original principal, buyer or seller, it's going to be really hard for you to move on, whether you're on the buy side or the sell side, right? So kind of how stubborn do you want to be? I'm not saying that you should be giving legal advice to your clients. I'm just saying you ought to set something in their mind, which is, what is the most important thing for you, client? Is the most important thing for you to sell your property if you're a seller? Or is the most important thing for you to fight with this buyer who you think did you wrong? Think about that and how it might impact your decision. Okay. Switching financing. We hear a lot about this in two ways. Somebody comes in with an all cash offer and then tries to get a loan, or maybe successfully gets a loan and wants to pay for the property with a loan. Or I also hear the situation, somebody comes in and they say, I'm going to get a conventional loan, 20% down. And what's the first thing they do? They apply for a 3% down FHA loan, right? So really they've mischaracterized how they intend to buy the property. The issue is there anything a seller can do about it? Is there any rights that a buyer has? Okay. We have a buyer stated financing paragraph. I'm going to show that in just a moment. Talk about that. But to me, the most important part, especially anybody who's working with sellers, a buyer's coming in, the buyer's making a representation concerning financing. The most important thing you can do is not focus on that buyer stated financing paragraph. That's a paragraph that really comes into play after there's been a default, okay? The most important thing you could do is focus on the verification of funds paragraph. Find out early, does the buyer really have the cash available? Does the buyer really have that 20% down payment? Find out early, because either you won't accept the offer at all, or you will be able to give a notice to buyer to perform early rather than waiting till there's a dispute later in the transaction. A lot of sellers feel they were taken advantage of in these situations where the buyer says, I'm paying all cash, and they come in and they have the ability to get a loan and pay with a loan. And I have to tell you something I think you have to discussion you have with your seller, which is, you may feel hurt, but if you actually been damaged, if the buyer is able to close on time at the set purchase price. You may not have any damages, talk to your lawyer about it, but really what's more important to you, selling the property, or addressing your hurt feelings, okay? Again, being right versus having a transaction. Think about those things. Let me look at my next slide. So I talked about verification. If somebody's coming in paying all cash, what are they doing? Look at that second sentence. The offer is not contingent upon buyer obtaining a loan, right? So you're getting rid of the loan contingency by checking all cash. Notice, written verification of sufficient funds. By default, it needs to be attached to the offer. Listing agents, you got to do your job. Somebody brings an all cash offer. Have they attached verification of funds? Maybe they have attached verification of funds. Have you bothered having your seller look at it? Or do you say, oh, good, there's a bank statement, so we're fine? Well, great. You're selling a $2 million property and somebody submits a bank statement that shows they have $200,000 in cash in the bank. That's not a verification of funds, all right? Sometimes it's going to be a little bit trickier, in which case your seller's going to have to think about it. Maybe somebody says, great, look, here's my $5 million 401k account. Is that a verification? Well, maybe not, because maybe they don't have access to any more than, I don't know, 10% or 20% or 50% or wherever they're allowed to borrow against their 401k, right? So just having something attached does not mean that the funds are verified. You need to look and see what's attached and have your seller take a look. Paragraph H, so somebody who's coming in there saying, I need a loan, they still need to verify down payment and closing cost. Look at the default, and this is in paragraph 3H. The default is 3 days after acceptance. Obviously, it's going to be a stronger offer if you bring that verification and attach it to your offer. But this is where I say, listing agents, do your job. If you're not countering that to make sure the verification comes with the offer or with the acceptance of a counter offer, then you better pay attention with 3 days and make sure that that verification comes in and check that the verification actually does verify the funds, right? Does your 20% down payment buyer really not have 20% down because they're going to be going for an FHA or a VA low down payment loan, okay? So you need to check on that, much more important than the buyer stated financing paragraph. I threw I there in as well, the appraisal contingency. You notice the default is the agreement is contingent upon a written appraisal. That is true whether the buyer is getting a loan or whether the buyer is paying all cash. The default is there will be an appraisal contingency. But if that box is checked, then it's very clear there is no appraisal contingency. So those are the two contingencies that can be removed up front, the loan contingency and the appraisal contingency. Everything else, look down at the bottom there, paragraph 14C, you need to attach a contingency removal form. Finally, I'm going to get to paragraph 3K, buyer stated financing. Okay, so seller's relying on the buyer, right? Okay, the seller, I agreed to the purchase price because of what the buyer told you, but does the seller have a legal right to stop the buyer from getting alternate financing? The answer is clear, it is no. The seller cannot stop the buyer from seeking alternate financing. Okay. The only thing the seller could do is the seller has no obligation to cooperate. But here's something where I'm saying the seller says, well, I'm not going to cooperate, so I'm not going to sign escrow instructions that say your money is coming from a lender. Well, I differentiate that. I don't think, I say that is not cooperating. To me, that's affirmatively interfering with the buyer's ability to close escrow, okay? So here would be an example of the seller saying, I do not have to cooperate. There's no investigation contingency. The buyer made an all cash offer. The buyer's lender wants to send the appraiser to come and look through the interior of the property. I think the seller could say, no, you have no investigation contingency. I have no obligation to let anybody into this property. I don't have to go out of my way to make it easier for you to get financing that you told me you weren't going to use in the first place, right? So I distinguish that from interfering with the buyer's ability to close escrow. Okay. Let's see, the other thing I wanted to mention was this form right here. In today's market, probably important that you consider using a market condition advisory form, either from CAR or maybe your brokerage company has their own. Look at the topics it addresses: the offering price, how non-contingent offers work and what the risks are, what the broker recommends, how to deal with buyers, right, who are making multiple offers even though they only have the ability to purchase one property at a time, and seller considerations, right? So we think this is a really good form to use, especially in the market right now. I know I've had people, they say they want to have this form bundled with the purchase agreement. I'm not actually thrilled with that recommendation because markets change over time. So I don't think our purchase agreement should reflect one market versus another, a buyer's market, a seller's market, or a more neutral market. But it's become so important. That's what people are asking us to do. because they're afraid that they won't get this into their transactions on their own. That's it, I think. Yeah, that's it. I did have some other resources, but you're going to make this available. So if anybody wants to look at those resources, they can do so. Lisa, Tiffany, I know we went over. I apologize. You let me know if you want me to answer a few questions.
I think we have time. If you have time, we do have a few in there, and I do have one on my own regarding the verification of funds. So somebody sends me an offer to my listing and they include the verification of funds, and they're saying, look, I've got, $500,000 sitting here in this checking account. And I was like, okay, great. That's the money you're going to use, because that's what you're telling me, the money that you're going to use. Then 4 days before close, the escrow officer receives information that loan documents are coming in.
Okay.
How would I verify that those funds are actually going to be used? Because that's what the seller produced, but somebody said, just show them this and we'll get you a loan.
Okay, so here's something I think everybody needs to understand. At the beginning of the transaction, when you're verifying funds, whether it's all cash or a down payment, the purpose of that verification is to give the seller confidence that the buyer will be able to perform. It's not a guarantee that the buyer is going to use those funds, or that the buyer will not get money elsewhere, or that the buyer, won't, get an inheritance from somebody and use that cash instead, or get a loan and use that instead. And it's not a guarantee that the buyer is going to close the transaction. It's to make the seller feel more comfortable about accepting that offer. So if I'm a seller, the buyer comes in, the buyer's provided verification of funds, I could feel pretty good about that buyer. That buyer may breach, that buyer may not perform, that buyer may cancel for a variety of reasons. There is no guarantee, but I feel a lot better about accepting an offer from an all-cash buyer that provides proof of funds than I would from an all-cash buyer who shows me a bank account with $10,000 in it, right? So it's to help you distinguish between offers. That's where it is relevant. It's not really relevant at the time of close.
So as long as the money gets into escrow and it closes on time, that's all the seller and the listing agent and the escrow officer should be worried about then, correct?
In my view, yes. And that goes to my issue. The seller who says, I was misled, you may have been misled, but you were not harmed. Okay.
I think that's really the important part to take away from it. So many of us are feeling like I've been lied to. And as long as they can perform, they can perform.
Right. And that's the issue. But for performing means performing on time at the purchase price.
Okay, great. All righty. Let's see what else we've gotten here pretty quick. I'll try to put it in the order here. Let's see. If they offered conventional switch to FHA, can the seller refuse the FHA appraiser to gain entrance? And the FHA appraisal is attached to that property, which is a little different than a conventional appraisal.
All right. Well, again, can the seller refuse entrance if it is during the investigation period? No, because the buyer can have anybody the buyer wants accompany buyer during the investigation period. If there is no investigation contingency, it goes back to what I said before. I think the seller would have the right to say no.
Okay, I'm going to come up to one that's regarding the unvaccinated buyers. Doesn't that discriminate against unvaccinated buyers? I know they are not a protected class, but if they are willing to wear a mask. And I bring that up because of the addition of the protected class, any arbitrary group.
Yeah, so that's a good question. And is it arbitrary to say, to distinguish between people with vaccinations and people without vaccinations? And only time will tell whether it's arbitrary. I have a feeling with the current environment, even a court, right, takes a while for cases to get to court. Court's going to be looking back in time. What's a court going to be looking back at? The court's going to be looking back. We're in California. And there's a big push nationally, but there's an especially big push in California for vaccinations. That's the mindset in California. That's where we live. That's where the properties are located. So a court, a year or 2 years from now is going to be looking back and say, it doesn't matter how we feel in 2024, whether it's arbitrary or not. It's really going to matter was it arbitrary back then in 2021? And I have a feeling the court would say that was not an arbitrary distinction for the times that we're living in right now.
Okay, and we'll go with one last question. I'm sorry to all of those whose questions we were not able to address, but we'd be here till 3 o'clock or whatever if we did. Regarding the fire zone, if the statutory NHD determinations is no, but in the county or city level it says yes, do we need to comply and give the form to buyer to sign?
Okay, so it depends on whether the local zone is considered a high and very high fire zone. Okay, and it might be, and that's an issue that I don't have the expertise to give you an answer on. It's something you'd really have to discuss with a natural hazard provider. Wow, not the way I wanted to end, but that's okay. We'll take what we got. We've held people over 15 minutes already, and I know we don't generally like to do that.
Well, I think our attendees appreciated it. We have a lot of wonderful comments in here on how informative this was. So I want to thank you, Neil, so much for taking the time to present with us here, and to all of our attendees. This is going to be recorded and it will be available. Check the Orange County Realtors website. I'm sure the link will be posted. And we just want to thank everybody for attending and hope you all have a wonderful day.
Lisa, just before I go, I just want to remind those who are still here, remember, I think Tiffany was telling me she's been working with the fire agencies in your area. She's been following what's been going on with Cal OSHA. So pay attention so you can get updates from your local association there as well.
Wonderful. Thank you. Yeah, our risk management committee is like really busy. So, but thank you again. And we so appreciate, and hopefully we'll have you back soon because I'm sure we're going to have more stuff coming up.
Okay. Thank you. It's a pleasure to be here.
Thank you.